Thank you. So this California case, this California lawsuit, was the celebrated one, most celebrated of the lawsuits against the oil companies. So this case involved the cities of San Francisco and Oakland suing the 5 major oil companies for damages from the climate change, which their product allegedly caused. So the plaintiffs were the cities of San Francisco and the city of Oakland. The defendants were Chevron Corporation, ExxonMobil Corporation, British Petroleum, Royal Dutch Shell, and ConocoPhillips. So those are the 5 largest investor-owned producers of fossil fuels in the world. Investor-owned means they're private sector companies. So lots of countries, the oil producers are government-owned. British Petroleum at one point was a government-owned company, actually. And so they were suing the 5 largest investor-owned producers of fossil fuels in the world, and these were, according to the plaintiffs' statistics, their carbon dioxide emissions and their methane emissions were 11% of the total greenhouse gases produced since the Industrial Revolution. So now the suit was in the United States District Court for the Northern District of California, which is San Francisco. The judge for this case was Judge William Alsop. He was 73 years old, appointed in 1999 by President Clinton. He was born in Jackson, Mississippi, went to Mississippi State University, and he must have been a very good student there because he ended up following that up by going to Harvard Law School. And after that, he became a partner at Morrison & Foerster, which is known as the top law firm in San Francisco by reputation. And so he proved to be a hard worker and a very serious and studious student, and that showed in this case. Now, the oil companies hired the best corporate litigation law firms in America by reputation. So all of the most famous law firms, corporate law firms, these oil firms hired. The most prominent that they hired was Paul Weiss, Rifkin, Wharton & Garrison in New York City, and their top litigator was basically ceded to as the top litigator in the lawsuit. So those lawyers decided early on they were going to concede the science and they were going to fight it out on the law, which is to be expected because these were the top lawyers in the country, so they were more comfortable fighting it out over the law. And in this case, that worked. That was a common thing you would expect from the corporations. Corporations are not really going to fight on the science. And these lawyers were not going to choose to fight over the science. They don't know anything about the science. They know everything about the law. And that turned out to be a very good strategy for them that has worked well in this case and promises to continue to work well in the near future. So Judge Alsop started out by scheduling what he called a climate science tutorial. So that was a hearing in which he invited both parties and their experts to present their views on the underlying science questions, starting out with underlying science, the climate change science, starting out with a list of questions he posed. Now, for us at Heartland, this posed a conundrum for us because we're deeply concerned about the science, science of climate change. That's our most important issue. But we had nobody representing our views in this tutorial. The lawyers were not going to represent our views. The oil companies were not going to stand up and challenge the climate science the way we would. And so we had to try to figure out how to insert our views into this tutorial so we'd have some representation. And I think we actually succeeded at that. So we supported an amicus brief written first by Lord Christopher Monckton and his colleagues. And they had a unique perspective actually on the climate change argument. Then we helped with another amicus brief filed by MIT physics professor emeritus Richard Lindzen and Princeton physics professor Will Happer. And both of those eminent scientists, they have long collaborated with Heartland and produced a lot of the background science that formed the foundation of the voluminous series Climate Change Reconsidered 2 and the Heartland book, Why Scientists Disagree About Global Warming. Now, for Heartland directly, we published a couple papers answering Alsop's questions, but instead of filing an amicus brief on those cases, which led to questions questioning what our funders were, which we did not want to disclose in public, we decided to post our papers on our website and publicize them, which we thought would work as well as trying to file it on the court docket. And then Joe Bast and I also published an article on the key issues in the Wall Street Journal editorial page. So we felt that the tutorial actually worked out okay for us, given the cards that we were dealt. So the complaint was originally filed in California State Court, alleging a single claim against the 5 oil company defendants for public nuisance under California state law. The oil company lawyers moved to remove the suit to federal court, which they won. They got the court removed to federal court, and the cities filed a motion with Judge Alsop seeking an order to remand it back to state court, which they felt would have been a much better venue for them. I think that was wishful thinking on their part. I don't think the state courts really are going to be a better venue for them. Even with the state courts, they were not going to be able to keep it out of federal court on appeal. So, but the lawyers were very successful in convincing Judge Alsop that it needed to stay in federal court and needed to be governed by federal common law of nuisance rather than the state law of nuisance. And Alsop eventually issued a ruling, and his ruling basically said, look, this is a global issue affecting worldwide emissions of fossil fuels and affecting the entire seacoast, which is eventually going to encroach on the cities of San Francisco and Oakland. So this is something that needs to be as general a national rule as possible, so it needs to be decided in federal court under federal common law. And the cities felt that that was the first road to ruin for them. So the plaintiff cities had to deal with this case being decided in federal law, so they filed amended complaints alleging a separate additional claim for public nuisance, under the federal common law. And then the defendants moved to dismiss the amended complaint for failure to state a claim on which relief could be granted. Now, this is a very special motion under the procedural law, because what that motion does is it sets up the whole argument then as the argument becomes, even if everything the plaintiffs say is true in their complaint, would they be entitled to recovery under the law? That's what a motion for failure to state a claim means. It means, okay, let's say everything that they said in the complaint is true. Even if everything they say is true, they still are not entitled to recover anything under the law. And that's oftentimes a difficult motion to win. So on a failure to state a claim motion, the judge is constrained by procedural law to take everything that the complaint alleges as true. So keep that in mind, because in the future this case is going to be cited as saying, well, the judge recognized that the alarmist view on climate science is right. And the thing is, the science was not litigated at all in this case or on this motion. There was no litigation on the science at all. So everything the judge said in the complaint, said in his decision, anything factual, he was constrained to accept what the plaintiffs said in their suit as in their complaint is true. So there was no litigation over the science at all. So every statement he makes under the science needs to be discounted on that basis. But now, so for the future, the fact that it was decided for a failure to state a claim on which relief could be granted means that the opinion ultimately dismissing this lawsuit is even stronger for our side, basically, from our perspective. Makes the decision even stronger. So the judge started out in his opinion, and he said, the issue in this case is not over science. That was the first thing he said. All parties agree that fossil fuels have led to global warming and ocean rise and will continue to do so, and that eventually the navigable waters of the United States will intrude upon Oakland and San Francisco. The issue is a legal one, whether these producers of fossil fuels should pay for anticipated harm that will eventually flow from a rising sea level. So again, so all those statements of fact he was constrained by the procedural rules to take all those statements of fact as true as alleged in the complaint. So those issues were never litigated. Those facts, there was no litigation over those facts. He had to accept them as true because it was a motion under Rule 12b-6, which is failure to state a claim upon which relief can be granted. So all those findings of fact in here are procedural findings of fact. There was no litigation over fact. There was no fact litigation at all over any of the factual statements in this case. And we need to keep that in mind in the future. But the fact that the case took the alarmist science as true makes the ruling even stronger from our perspective. Even if the alarmist science is true, they still lost. And so that makes it an even stronger final opinion. So the specific nuisance alleged in the complaint was global warming-induced sea level rise. That's how they were a nuisance. Their nuisance was that their product produced a sea level rise that eventually was going to intrude upon the cities of Oakland and San Francisco. Now, then I'll turn to the federal common law of nuisance. And he said the common law of nuisance boils down to whether the defendant's conduct, which was otherwise lawful and a lawful everyday sale of fossil fuels, produced an unreasonable interference with invasion of plaintiff's rights. The question was whether the nuisance, the invasion of plaintiff's rights, whether that was unreasonable. Now, the term unreasonable, the judge recognized, the term unreasonable in the common law contemplates an underlying cost-benefit analysis. And that's ultimately where the case was lost there by the plaintiffs. The judge's opinions, he seemed to be reading Steve Moore and Kathleen Hartland-White's book on fueling freedom. And so his opinion eventually started to sound like the book Fueling Freedom. So now it's also interesting. So another interesting fact, which was not alleged by the plaintiffs, but was an observation, an obvious observation of the case, was that, look, the defendant oil companies only produced and sold the fossil fuels, which does not involve any emission of carbon dioxide at all. So nothing the oil companies did actually produced any emissions of carbon dioxide. It was the plaintiff cities that bought the fossil fuels and used them, which is what produced the carbon dioxide emissions that allegedly caused global warming. So if it was global warming that was causing the invasion of the city, it was the cities, if carbon dioxide was causing global warming, it was the cities that produced the carbon dioxide. The oil companies didn't burn their own fuel. And Judge Alsop did notice that. So that was a bad start for the cities. So Alsop then went into his cost-benefit analysis. So he said, with respect to balancing the social utility against the gravity of the anticipated harm, it is true that carbon dioxide released from fossil fuels has caused and will continue to cause global warming. Now, that's not a finding of fact based on litigation. Again, he was constrained to take that as true because it was a Rule 12b-6 motion. It was a failure to state a claim motion, so he had to take whatever the complaint said on that point as true. So that's why he said it is true that carbon dioxide released from fossil fuels has caused and will continue to cause global warming. Now, the left is already citing that observation as, proof that their side has won the debate over the global warming science. But the case didn't involve, there was no litigation on global warming science at all in this case. And then he said, but against that negative, we must weigh this point. Our industrial revolution and the development of the modern world has literally been fueled by oil and coal. Without those fuels, virtually all of our monumental progress would have been impossible. All of us have benefited, having reaped the benefits of that historic progress. Would it really be fair to now ignore our own responsibility in the use of fossil fuels and place the blame for global warming on those who supplied what we demanded? Is it really fair, in light of those benefits, to say that the sale of fossil fuels was unreasonable? So that's where he lapses into basically repeating Fueling Freedom. He could have just cited Steve Moore and Kathleen Hartland-White right there, because it started reading just like their book. But the case ultimately turned not on that observation, but ultimately turned on a U.S. Supreme Court precedent in 2011, American Electric Power versus Connecticut, which held that the Clean Air Act and EPA's regulatory authority under the Clean Air Act displaced or effectively preempted federal common law nuisance claims. And so, in fact, even the Ninth Circuit itself, in a case called Kivalina versus ExxonMobil, held that the Clean Air Act and EPA's regulatory authority thereunder disputed claims for damages based on oil producers' past carbon dioxide emissions. So fossil fuel producers cannot be sued for carbon dioxide emissions. That's because based on Supreme Court precedent, they've already said you can't sue them for carbon dioxide emissions because the Congress has said that The EPA, the Clean Air Act, is their solution to carbon dioxide emissions, and the EPA is the one who's given the authority to weigh the costs and benefits, and it's not a matter for federal courts. So bottom line, fossil fuel producers cannot be sold for carbon dioxide emissions. That's what the case stands for. Now, what about the carbon dioxide emissions from the production, use, and sale of the defendant's defendant's oil outside the United States, where the Clean Air Act does not apply and the EPA has no authority? So the lawsuit is displaced, is preempted within the United States because that's where the Clean Air Act and the EPA has jurisdiction. But what about the carbon dioxide emissions that these 5 defendants produced outside the United States? A couple of them were actually foreign oil companies, and they produced their fossil fuels. So went worldwide. The carbon dioxide emissions went worldwide. So they were still causing the sea level rise. But again, the court said, based on U.S. Supreme Court precedents in 2 cases, Sosa versus Alvarez and Jesner versus Arab Bank, he said plaintiffs' claims regarding such international emissions from fossil fuel use should be reserved to the legislative or executive branches, which can far better balance policy concerns regarding the harmful effects of greenhouse gas emissions and our industrialized societies' dependence on fossil fuels and the economic effects of regulatory and liability responses. Also, national security issues. So there, the judge was referring to the fact the military used fossil fuels to win World War I, win World War II, and ultimately prevailed in the Cold War because of the threat of responses based on fossil fuels. And so, again, this was another cost-benefit analysis. So the law was considering the correct issues. Notice the Obama administration, the focus was the social cost of carbon. Social cost of carbon. Our emphasis in response has been the social benefits of carbon, and in fact, the courts the thing worked, even though we feared that we would end up with a very biased judge who had made the decision in advance. In fact, they considered the right questions, and then they had the right answer. So Alsop ultimately wrote, the challenge conduct is, as far as the complainant alleges, lawful in every nation, meaning that the sale of fossil fuels is lawful in every nation. Many foreign governments actively support the very activities targeted by plaintiffs' claims. Nevertheless, plaintiffs would have, this was a famous quote from the case which resonated nationally, the plaintiffs would have a single judge and a single jury in California impose an abatement fund as a result of such overseas behavior. Because this relief would allow plaintiffs to govern conduct and control energy policy on foreign soil, we must exercise great caution. So the bottom line there was that they were, the bottom line there is that, you know, again, you know, just like domestically, it was all preempted by the Congress's, the Clean Air Act and Congress's establishment of the EPA and the authorities of the EPA, which we have to defer to, even in overseas conduct, which they were the Clean Air Act and the EPA has no jurisdiction. This is another area where we have to defer to the legislative branches and to the executive branch. It's really their decision to work this out, and this is not an area which the court should try to step in and resolve this whole issue. It should not be left to a single judge and a single jury in California to solve the worldwide problem of global warming, which was a remarkably constrained result.
Peter, we have to wrap it up.
Okay, so there was later there was, I'll be done in a second. So later in the case, there was the New York case, and the New York case was very similar. The city of New York sued the 5 oil companies, and the opinion in the city of New York read almost exactly like the opinion in California. So these are 2 very valuable precedents, and it indicates that the oil companies are not going to be held liable cannot be held liable in U.S. courts.